a business record. And of course, the emergency room report records the treatment of the defendant and all the statements that he made during his time in the ER. But the defense objects because of the doctrine of Johnson versus Lutz. Remember, I told you one of the limitations of a valid, admissible business record is that it's only admissible as to that portions of the business record that are the business of that business. And if it's none of that business's business, then it's stricken and not admissible. So in this instance, you got an ER doctor, and everything the defendant says to him about, you know, I hurt my knee, I hurt my sternum, and I got high blood pressure, I take this kind of medication, and so on, all of that is relevant to diagnosis and treatment. And all of that is a proper part of the business record. Whether he ran a light or not has nothing to do with diagnosis and treatment. And it's outside the scope of the doctor's business, and so it's excluded from the business record under Johnson versus Lutz. But it's still admissible because it's coming out of the defendant's mouth. So the business normally you would take that out of the business record. If it was somebody other than the defendant that had made that statement, that would be stricken from the business record because it's not the business of the business, but it's admissible here as an admission. That's why hearsay is so much fun. Number 6. We got a witness who testifies that her friend, her girlfriend, was afraid of the defendant after they broke up, right? Is one of these controlling freaks. And so the witness, okay, so this is somebody testifying at trial, wants to tell the jury that the victim, who's now dead, of course, kept a diary in which she wrote down all of the harassing phone calls, all of the unwanted visits, I mean, all of the, you know, everything that the defendant did that she was concerned about, as soon as they occurred. The trial witness testifies that she's familiar with the victim's handwriting, so she authenticates the diary, the handwriting, that's the victim's handwriting. And then the state says, okay, we want to introduce the entire diary for the days preceding the murder, and the defendant objects on hearsay grounds. Mariana Yee, you think the prosecutor can get this in? Where are you, Mariana? Okay.
I think it is hearsay.
You're going to overrule the objection? Or are you going to sustain the objection?
Sustain it.
Look at 803.1. Present sense impression. A statement describing or explaining an event or condition made while or immediately after the declarant perceived it. It's what's called an unexcited utterance. So if the victim truly made a notation immediately, I mean, at 10:30 at night he made a harassing phone call, at 10:35 she writes in her diary, he made a harassing phone call, and she's consistent with that, it meets the qualification of a present sense impression and would be admissible under 803.1.
But is it the first, like the diary that they're saying is hearsay, or like the witness?
No, the diary entries. Right, I mean, the witness is testifying, this is her diary, here it is. And then the diary itself is the victim writing, on Monday, he came by my work and he harassed me. On Tuesday, you know, he sent me a rude text message or whatever. And all of that, as long as the victim was recording stuff while it was happening or right after it happened, is present sense impression.
Wouldn't you have to prove that it's the victim's handwriting, though?
Yeah, no, that would be the foundation for getting it in. And so, in the problem, I have the girl say, yeah, I'm her best friend, I know what her handwriting looks like, and this is her handwriting. So that's another issue which is called authentication. All right, 7. Now, the police officer's on the stand testifying at trial. The police officer says that when he showed up at the scene of the domestic fight, the victim was hysterical, crying, shaking, her face was flushed, and she was yelling, "That bastard tried to stab me again." The defendant is now on trial, charged with assault on a household member, and the victim doesn't show up. The prosecutor wants to be able to have the jury hear the officer testify about what the victim said to the officer when he first showed up. Is that admissible? Rachel Zavala. (803.2). That's your classic excited utterance. As long as the person who is making the statement, the declarant, has just suffered some kind of traumatic event and is still under the influence of the trauma. So she's hysterical, crying, and she's shaking, and her face is flushed. And that's the foundation the officer has to lay before he tells the jury what it is that she said to him. But if he says those things, if he testifies to those things, he's laid the foundation for an excited utterance. Now, as a matter of applied psychology, when somebody's freaked out like that, it doesn't make their statements more reliable, it makes them less reliable. I mean, they might, their perception is off, and there's all sorts of problems with it. But we have recognized in the common law the excited utterance for a long time, on the supposition that it's a reliable statement, because if somebody's that freaked out, they're not really thinking about telling a lie. Number 8, the witness seeks to testify that on the night the victim was killed, the victim told the witness. So the witness on the stand, the victim told this witness that she, the victim, was afraid of the defendant, and she wanted to move back to Kansas to get away from him. The defendant objects on hearsay grounds. How do you rule? This one is hard, but it's the 803.3, then existing mental, emotional, or physical condition. The witness can testify about what the out-of-court declarant said that they intended to do. So the part of that that's admissible is that they intended to move back to Kansas to get away from him. The part that's maybe not admissible is that she was afraid of the defendant. Now, this is another wrinkle on that same thing. Defendant's mother, this is the defendant's mother, testifies that on the day the victim was killed, the defendant called her and told her he was going to the victim's apartment to cook her dinner in hopes they could get back together. That's all admissible because it's an admission. It's not hearsay, because it's something the defendant is saying. Suppose the phone call was not from the defendant, but from the victim. The victim tells the defendant's mother, it's her mother-in-law, right, or her boyfriend's mother. The victim tells the defendant's mother that she expected the defendant to come by her apartment to cook her dinner and that they would make up that night. May mom testify over her son's hearsay objection? And the answer is under 803.3, that's a no. Why? Because 803.3, you're only allowed, the in-trial witness is only allowed to testify about something the declarant said that expressed what the declarant intended to do. The problem with this one is that the declarant is saying she expects the defendant to come by her apartment. But it's only admissible if the declarant says, I'm going to go by the defendant's apartment. If the declarant says the defendant's coming by my apartment to cook dinner, we're going to make up, then she's expressing her view about what the defendant is going to do, and that's not a then existing mental, emotional, or physical condition of the declarant. So it's not admissible. Business records number 10 from Memorial Medical Center include entries made by the triage nurse, physician, recording statements made by the defendant while he was being treated. All of that's admissible because it's an admission, it's not hearsay. Now, a part of this is he says that the victim attacked him with a baseball bat, and that was why he had to strike her back. These portions of, well, these portions are still admissible. The part about the victim hit him with a baseball bat, because those are classic business records, 8034, they're necessary for diagnosis and treatment. They are the business of the emergency room. So they're admissible. Normally, an admission by the defendant is not admissible if it's helpful to the defendant. But in this weird little scenario, it is. Number 11.
So was this one hearsay or not hearsay?
It is not hearsay except the part about she hit him, because that's helpful, so that's not an admission. And that's an exception to the hearsay rule for the business record. Because it was necessary for the doctor to know that somebody hit him with a baseball bat. So it was necessary in order to do the diagnosis and treatment, you gotta know what he was hit with. So it comes in as a business record, the portion of it that says the victim hit me. And then the other portion is just to the extent that it's harmful to the defendant, is not hearsay because it's an admission. So it's a combination of both. Number 11, and this is why it's fun to be a trial judge. The defendant testified he did not run the red lights. The defendant's taking the stand at his own trial. The state wants to introduce the accident report prepared by the officer that contained a statement he took from an eyewitness that he saw the defendant run the red light. This eyewitness did not unfortunately respond to the subpoena, and they failed to come to trial. Is the accident report admissible or excluded as hearsay? And that's the specific exception for public records in 803.8.2. 803.8.2 says public records are an exception to the hearsay rule, except a matter observed while under the legal duty to report, but not including, in a criminal case, a matter observed by law enforcement personnel. Now, in this case, the officer was not the one who observed that the defendant ran the red light, but nonetheless, basically, accident reports, police reports in general, are not admissible. And there's a reason for that. Of course, that would make it far too easy to prosecute people, because every time when the police prepare police reports, then you would just come to court and introduce all the police reports, and that would also violate the right to confront your accusers. Skip number 12. Number 12 is an example of the sort of catch-all. There's a catch-all thing, but I'm not going to bother with that. Now, 13 is a good illustration of an important distinction. May the state introduce the grand jury testimony of a witness who has subsequently died at the indicted defendant's criminal trial. So we had a witness, an eyewitness, some kind of witness to the crime. And they testified at the grand jury, but by the time we get to trial, that witness is dead. So the state wants to introduce the transcript of their testimony that they made to the grand jury. Sandra Apodaca, what do you think? Where are you? Over there, okay. Well, testimony, right? Testimony, let's see. No, you can't introduce it. It's definitely hearsay, because it's an out-of-court statement being offered for the truth of the matter asserted. But the problem is that if you look at let's see. What am I looking for? Oh, prior statement. Well, yeah, I mean, the distinction is that, wait, here we go. Declarant witness's prior statement